Good morning friends, Adab, Sat Sri Akal. Now this is a very important video and it is a little lengthy video. You will have to make patience because this is a very funny happening in this present government, where most of the people keep harping, this government has done this government has done that. Can you imagine what is this government doing? This government is amending the GGO-179 of 1836, wide an order of Ministry of Defence number 14, bracketed 19/2017-D, dated 7/5/2021. It has decided to bring in Parliament approval to the procedure to be formulated to regulate the transfer of properties within the cantonment or the Cantt area. On 25th January 2021, the MOD decided that the amendment matter be taken separately than the Cantonment Bill of 2020. The Defence Secretary on 10th March 2021 decided that DGDE Lands will check in the various policies framed by the MOHUA and the DDA or other central agencies or department. DGD will make a presentation of complete number of bungalows and how many breaches or major violations of grants and legal framework for the amendment. On 22nd March 2021, the DGD made a presentation with the Defence Secretary and gave a detailed doing of how the change be effected in grants of the terms medical officers, army officers, government staff, native and value restriction of 5,000. The submissions made were that in 1941, the British government had delegated its authority to deal with old grant properties, including permission for sale of authorized properties in the civil area to the Cantt Board, but was withdrawn in 21961 order. This is also mentioned in CLA rules and it fully speaks of full cantonment as in 1937 CLA rule 2 civil area was notified. DO was given powers in 1951 for the same purpose but was withdrawn in 1970. Note, this is very interesting and proves the point that in 1941 a military letter mentioning the CLA rules was for the whole of the cantonment civil area. After independence, the Government of India decided to take away the powers of the Cantonment Board. Again in 1978, the DGDE Land was given powers for mutation and permission for sale of bungalows. But in a case of Bareilly cantonment, in 2019, the approval came from the MOD. So the DG was again not given powers, bungalow number 27. So DGD admits that there should be more than about 49,000 old grants in these 57 cantonments as stated by Amit K. Mishra, DG Lands 2 in a document of report. Now what were the proposals and amendments to be done in the Governor General Order 179 of 1836? So be prepared. All your grant terms are going to change. Now what is that change? We will discuss that regulation wise. Regulation number 1. Remember I had spoken of this resolution in my earlier video. Now there is no change in this regulation. Regulation number 2. It has no change. Irrelevant as on date, all old grants are occupied. So nobody is applying for an application. Similarly, regulation 3, no change. Now government, when no objection occurs, the application is to be forwarded through the prescribed channel by the Cantt Board, DO to the MOD, and NOC be availed or rejected for sale or purchase or division of old grant. Why can't this be added? Leave it at the local level. Na? You want a betterment of the cantonment. So, I propose this change. Regulation number 4, no change. Well, this is omitted. Now, it says, since all grants are already given, no new grant is coming. So, let's omit this of application for grant. Coming to regulation number 5, grants are to be registered. Again, the government says no change. I submitted, why not? Let's have a change. Old grants to be registered and noted on plan. All grants are to be registered by the city magistrate or of the cantonment. And all old grants are to be immediately noted upon the survey plan of the cantonment, and a copy be given to the Survey of India office for permanent records. This is what we asked for. Coming to regulation 6, condition of occupancies. Now the government is proposing an amendment. What is it saying? No ground will be granted except on the following conditions, which are to be subscribed by every grantee, as well by those to whom his grant may subsequently be transferred. What is to be added to the amendment which the government is looking in this condition of occupancy? No ground oblique old grant. Again, I added the word will be granted except the following conditions, which are subscribed by every old grant occupancy holder, as well as by those to whom his grant may subsequently be transferred oblique inherited. Nothing wrong. First, resumption of land, the government to retain the power of resumption at any time on giving 1 month notice and paying the value of such building. I am asking, at any time on giving 1 month notice authorized to be erected or has been standing at the time of resumption when notice is issued. Now there comes a dispute. So this is, I have asked for an amendment. The second, land belongs to government. Government land cannot be sold by grantee. Transfer of houses between military officers, the ground being in every case the property of government, cannot be sold by grantee. This is the government proposing the amendment. I am asking, please, if you want this amendment, add these things. Second, land belongs to government, but the holder of occupancy rights or old grantee can sell the built up estate between any countrymen after approval. The ground being in every case the property of government cannot be sold by the holder of occupancy rights or old grantee. Why can't the government change this? The third part of regulation 6 is being also changed. What is the amendment being done? Transfer of houses and building properties. If the ground has been built upon, the buildings are not to be transferred to any person or whatsoever description without the previous sanction of such authority as may be prescribed by the central government. I am saying accepted. Fourth part of the transfer of native, provided that the buildings are situated in an area other than civil area, the previous consent of the officer commanding the station from security point of view should have been obtained. So what have I added? Other than the civil area. So at least let the civil area, now since the government is saying to excise it, provided that if the building are situated in the civil area, the same may be transferred with the previous sanction of the Cantt board and not of the commander-in-chief. Regulation number 7, they says house claimable for purchase, no change. Now I say, again change. Bring the influx of holder of occupancy rights or old grantees. Get our name in it, na? Address us with this name. So, and what about the amendment of those GGOs which were amended in 1855? Government is again speaking nothing of those amendments in these. It is only talking of the GGO which was originally made in 1836. So these amendments have to be a part of it. So now friends, we have to understand that Regulation 8 again is being amended. It is saying the committee is to be composed of the collector or the deputy commissioner of the district in which a committee is cantonment is situated, or a magistrate nominated by him, the officer commanding the station or military officer nominated by him, and a person nominated by the proprietor of the premises, and their decision whether relating to the terms of purchase rent is to be conclusive unless it is reversed by the government of the committee of arbitration, or to be submitted whenever the proprietor of the premises which they have valued is dissatisfied with the award. Now here I have asked for a very small, why not have a time frame that this committee has to give its report within some particular 3 months, 6 months, like that, because nothing has been said in the earlier parts. Now arbitration in case of transfer, Regulation number 9, the ministry at present is omitting it. It says we do not read Regulation 9. Regulation 10, it says again we are omitting it. I have added a new rule, and which will be called Regulation 9, power to make rules. The government may either generally or specially for any cantonment or group of cantonments after previous publication make rules consistent with these regulations to regulate all or any of the following matters: A. Resumption of land as per paragraph 6. B. Application for disposal of building pursuant to paragraph 6. Assessment of value of authorized building. Procedure for the committee of arbitration, and any other matter in respect of which the government is empowered to make rules under these regulations, or in respect of which these regulations make no provision or makes insufficient provision, and further provision is in the opinion of the government necessary. So these are the amendments or objections which were filed by the All India Cantonment Bungalow Owners Association, as the president Mr. Raghavendra Das had done. Has the government responded? No. So we have to understand, government is not interested in doing anything. First of all, I find it very funny, why is the government amending the GGO-179? So friends, please wake up. Watch my videos. Thank you. Good day.